Welcome to Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now you can learn about the law and how to protect yourself against the loss of your liberty or property. Learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is Attorney Kenneth J. Landau with the Mineola Law Firm of Shane, Dox, Denisi, and Corker. He's a member of the Committee on Professional Ethics of the Bar Association of Nassau County and counsel to the Nassau Academy of Law. And now, here is your host for Law You Should Know, Attorney Kenneth J. Landau.
Hi, this is Ken Landau, and welcome to Law You Should Know. Today we're going to talk about the new rent regulations law in New York City, and also it applies to some buildings in the suburbs as well. A few months ago, there were very dramatic changes to the law, and we have with us as one of our experts on landlord-tenant law, Linda Rzesniowiecki. Her office is based in Manhattan, but she certainly handles cases in the city, all over the city, usually on behalf of tenants. There are very few experts on landlord-tenant law for tenants in New York, so it's important to know about her. So even if you know someone has a building, if you know someone as a tenant, or you may be a tenant or landlord yourself, it's very important to be aware of these changes. Linda, welcome back to Law You Should Know.
Thank you, Ken. Thank you for inviting me to be on the program again.
Okay, so this officially was called the Housing Stability and Tenant Protection Act of 2019.
Exactly.
So just start us out and just tell us how it changed, how it added to or deleted things in the real property law.
Right. First, it was signed into law by the governor on June 14th, 2019, and it is a dream come true for the tenants of New York State. A nightmare for landlords. I mean, property values have gone down in multifamily dwellings, particularly rent-regulated dwellings. And there's four parts of the law. I divided it in my head into four parts. We've got changes to the real property law, which applies statewide. We've got changes to the general obligations law involving, which pertains to security deposits, also statewide. We've got changes to the real property actions and proceedings law and housing court. And we've got changes to rent regulation and the state agency that oversees rent stabilization and rent control laws. Tonight I want to concentrate on changes to the real property law, which are very significant. For instance, I'm going to go in the number order of the statutes. Real property law 223B has to do with retaliatory eviction. Sometimes tenants assert their rights and landlords try to squash them. Okay? And the law previous to June 14th did prohibit that and they had a presumption in the law that if a tenant complained to a state agency or a city agency, or if a tenant took actions to enforce his rights under tenant's lease or under the law, or if a tenant participated in a tenant organization, that those things were presumed. Then if a landlord retaliated in some fashion, then it was presumed to be, that would be the retaliation would be a defense to landlord's action against the tenant. But we've got some new provisions. If a tenant complains to a landlord for breach of a warranty of habitability, that means a quality of life in the apartment. If a landlord complains about if a tenant complains about the landlord changing the terms of the tenancy, then those two could be considered retaliatory actions. And if a landlord brings a holdover or offers a lease with an unreasonable rent increase, or brings a non-payment proceeding within 1 year of any of those tenant actions that I mentioned, then it's presumed to be retaliation. And if a tenant brings a civil action for retaliation, tenant could get attorney's fees, plus a landlord will be required to offer this tenant that landlord is trying to evict lease renewal for a term of up to 1 year. So what is really far-reaching in this is the non-payment proceedings. Just think about it. If a tenant complains about a breach of a warranty of habitability, and landlord brings a non-payment action against a non-paying tenant, that's within 1 year of tenant's complaint, that's presumed to be retaliation. So even some tenant advocates consider that to go a little too far.
But that's the law. It's as you said, it was like a gift, more than they ever expected, more than they hoped for, more than they asked for, but it's a gift.
Right. So that's one thing, the Real Property Law 223.
Now before you go on, I just want to ask, just for our listeners, what are some other things that could be a breach of warrantability or habitability? Just explain what that term means and give us a few examples. And this is such an important term.
Sure. Now, let's say, a landlord doesn't provide heat in the winter. What if a landlord is not providing hot water at any time of the year? What if the landlord is allowing water to enter the apartment, constant leaks, and and the ceiling is falling down from the plaster that's wearing away from the water.
Even a little bit. If you have paint peeling, your ceiling's crumbling anywhere. What if you see vermin in your apartment? Bugs or rodents.
Well, rats for sure. Mice.
I think most people want to probably be ant-free or at least mice-free.
Right. But a breach of the warranty of habitability, there are so many cases about this, what's considered a breach.
So there are a lot of things. It would be, if the door wasn't working properly, the intercom wasn't working properly, if it was maybe dirt or something in the hallways or inadequate lighting. A lot of things might rise to that level. Is it important to do these things in writing or email, something written, so you can show the landlord did in fact get your complaint?
It's very important for a tenant to communicate with the landlord and or the managing agent by certified mail return receipt requested. And one of my favorites is priority mail, where you do have a tracking number and you could prove that the other person received your piece of mail. You could do email would work. If there's a reply to the email, then it was received.
If you send a fax, so you get your fax receipt, would that be good enough?
Maybe.
Okay.
Maybe.
So anyway, certified mail or some mail that's tracked by the post office or someone else is good. What if you were a whistleblower and you just claim they're discriminating or they're not complying with codes or they don't have permits for work, and you notify the agencies? Does that also protect you from retaliation?
A tenant complaint to a city or state agency of any kind, to the Department of Buildings, to HPD, to the Department of Environmental Protection, any agency, and if the landlord is angry about that and sits with it and does nothing against the tenant, okay, he'll have to suck it up. But if he then brings a holdover proceeding against the tenant within a 1-year period for a sort of a drummed-up noise complaint, an allegation that the tenant is too noisy, there's going to be a presumption that that case was brought on the basis of, on a retaliatory reason, because that tenant made a complaint to a state agency or city agency.
And does this tenant have to be named on a lease, or they could be a relative who also lives there? The complainant. The person who's making the complaint.
Good question.
You can think about that and let me know in the future if you want.
Okay, yeah. The statute talks about the tenant, tenant complaints or tenant's actions that... Well,
they are a tenant. They may not be a named tenant.
Yeah,
but we don't have to deal with that now. What else did you want to... What's the next topic you wanted to discuss?
One big change is now Real Property Law 227E. It used to be that if a tenant signed a 1-year lease on January 1 of a certain year, ending December 31 of that year, let's say, to make it easy, that if a tenant left that apartment on February 15th and gave a landlord 2 minutes notice, that the tenant would be responsible to pay rent each and every month, including the last month of December. Now, the statute makes clear that the landlord has a duty to, quote, mitigate his damages, unquote. So if a tenant breaks a lease and vacates prior to the end of the lease, the landlord must take, quote, all reasonable and customary, unquote, actions to rent the premises to a new tenant at fair market value or at the same rent, whichever is lower. And then once the apartment is re-rented, tenant's responsibility under the lease, of course, ends. So that's a wonderful thing. So
that they have that protection in law, and let's just explain for our audience, the mitigation means they have to go out and find a new tenant and do it in a way where to make the public aware about it.
Right. However, whatever the usual and customary means are of advertising apartments these days, that's what they should do. I'm not aware of all the methods of advertising an apartment, but there's Street Easy, lots of different websites and apps for the phone. So,
okay, what's another change, Linda?
There's a limit on late fees that a landlord might charge when a tenant pays rent late. Real Property Law 238-A(2). If the rent is not paid within 5 days after it's due, then a landlord may charge a late fee, but that late fee can be no more than 5% of the rent or $50, whichever is less. Now, in Tribeca, which is in the neighborhood I have my offices, I have seen rents of $10,000, $11,000, $12,000. These aren't poor tenants, I don't weep for them, but their late fees are limited to $50 if they don't pay their rent on time. 5% would be of $10,000 is way too much.
Okay, we're going to take a short break now. One question I want to ask you when we return is if the changes you're talking about apply to all tenants or just rent-stabilized or rent-controlled tenants. In any event, we're talking with Linda Rzesniowiecki. She's an expert tenant attorney, especially in landlord-tenant conflicts. You're listening to Law You Should Know here on 90.3 WHPC, the voice of Nassau Community College, and also over the internet at nccradio.org.
This portion of programming on WHPC is brought to you on behalf of the Nassau County Bar Association, who wants you to know about ADR, Alternate Dispute Resolution, which can help you avoid costly, lengthy, and uncertain litigation in court. By resolving disputes through mediation or arbitration, it gives you control over who decides your case. A mediator helps all parties to reach an agreement they can live with, or an arbitrator selected by the parties hears and decides the case. Your attorney can still represent you, but you control who decides your case. ADR is faster and less stressful than fighting in court, and it is a great way to resolve divorce, employment, or commercial disputes. ADR is now offered through the Nassau County Bar Association. Find out more about how ADR can help resolve your dispute by calling 516-747-4070 or visit nassaubar.org.
Once again, we continue with Law You Should Know. From the Mineola Law Firm of Shane, Dox, Denise, Corker, and Sauer, here is attorney Kenneth J. Landau.
Hi, this is Ken Landau, and welcome back to Law You Should Know. We're talking about the changes in the rent laws that came into being a few months ago. Many new tenant protections, which everyone should be aware of. If you know someone who's a tenant or you know someone who's a landlord, our expert guest is Linda Rzesniowiecki, who's a landlord-tenant attorney with offices in Manhattan, but she also does represent tenants in other places. Keep in mind, if you've missed any part of the program or you want to hear it again, it's available at the website, nccradio.org, and you can listen to the podcast and let your friends know about that. Linda, thanks for being our guest again. And if you can tell us quickly, does the changes you've told us about and will tell us about, do they apply to rent-stabilized tenants, all tenants?
Why I started with the real property law is because this applies to all tenants in the state of New York, rent-stabilized, rent-controlled, market-rate tenants, tenants in 2-family houses, tenants in 100 family houses. It applies to everyone.
And this is true even if you don't have a lease?
Yes, well, I could talk about if you don't have a lease, and you would be then a month-to-month tenant. And if a landlord wanted to end your month-to-month tenancy, the landlord has to provide you, if you have been a tenant for less than 1 year, with a written notice by certified mail of 30 days. If the tenant has occupied the unit for more than 1 year, but less than 2 years, it has to be a 60-day notice. And if the tenant has occupied the unit for more than 2 years, it has to be a 90-day notice. Those are the changes to real property law 232A.
And again, this applies to all tenants.
All month-to-month tenants in the state of New York.
In any kind of housing situation, rich or poor.
Any kind.
Wow.
Any kind. And also, if a landlord wants to increase the rent of 5% or more, the landlord has to give notices of the same sort, either a 30 or a 60 or a 90-day notice, depending on the length of time the tenant has been in occupancy.
And if they fail to do so, your rent is frozen at the old rent?
Yeah, they can't. Yeah, the tenant could just be free to pay the same rent. And if a tenant sues for non-payment, if landlord sues for non-payment, the tenant would say, I didn't get my 90-day notice. And that would be a defense.
So this is almost like a force field around tenants of rich and poor.
Right. And it doesn't distinguish between, what gets me is, the owner of a 2-family house who lives in the 2-family house is just a regular Joe or Mary, just a regular person. Yeah, and may not have very much money, but that the tenant in that two-family house is as protected as the tenant of any major landlord in New York City.
And that's why even a tenant, someone who's taking a tenant in may want to consult a lawyer and draw a quick agreement to protect them as much as possible.
Well,
and legal.
A lease. That would be a lease. Yeah. Now, let me tell you something else. What landlords have done in the past is they've hired, there are firms that do collect and have collected information from the housing courts about what tenants were sued in housing court for non-payment, for holdovers, so that if Joe Smith wants to rent an apartment, the person from the firm would look up Joe Smith. Goodness help them. I should have picked a different name, like Rzesniowiecki, and look up that name and see if they were sued. And if they were sued by a landlord for anything ever, in the past, a landlord would simply say, I don't want a troublemaker. I'm going to turn this person down. Now, due to Real Property Law 227F, that kind of blacklisting is prohibited. Absolutely prohibited.
And this is true if they were alleged deadbeat or they were a tenant activist, it's prohibited.
Right. What the law actually says is if a landlord requests information from a tenant screening bureau, or if the landlord inspects court records, there's a presumption that, a rebuttable presumption, that the landlord denied the rental to this tenant because of something landlord found in housing court records.
And what if can the landlord obtain a credit report, just like when you buy a car and you want to lease it?
Yes, a landlord could obtain a credit report. And there's another section of the law which says that, normally landlords collect fees from a tenant in order to run a credit check. That fee is now limited to $20, no matter how much it costs to run the credit check.
And usually the tenant or the applicant has to sign permission for the landlord to obtain it.
To do a credit check.
And they might be entitled to a copy of it so they can see if there's any erroneous information.
Absolutely, the law entitles them to a copy. So what would be smart for a landlord is don't collect the $20, run a credit check with permission, and then you don't have to provide a copy, I don't think, if you don't collect the money. So
it might have to do with when you obtain permission. I'm really not sure about that.
Yeah,
okay.
Yeah.
So anyway, Linda, tell us about all these are very interesting points. They're little points in a big set of laws with tremendous ramifications.
Right.
So tell us about some other changes that people can add to their Christmas stocking, if you will.
Yeah. Okay. Let's see. Okay. There's also, landlord has a duty to provide all tenants with a written receipt for the payment of rent. Now, the only time landlord doesn't have to do that is when landlord was paid by a personal check. Otherwise, a landlord has 5 days to give a rent. 5 days. Let's see.
Well, whatever it is, Linda, don't worry about the number. But
it's a certain amount of time.
But if a consumer is paying by check, should they make a copy of it for their files?
That's not a bad idea.
Since they're not going to get a receipt.
Yeah.
Okay.
Possibly. So,
we only have about 2 minutes left in the show. We will talk to Linda again in the coming weeks to learn more about some of the small but significant changes that affect landlord-tenant laws in New York State. So, Linda, just anything for summary. And I do want to mention that the sections you've heard her mention, probably the hardbound books are available at your local libraries with cases discussing them or the books having some explanations of them. Or you can probably Google them, or your local librarian can assist you in looking at them. Please remember, this is information only, and if you're a landlord or a tenant, you should consult your own attorney, someone like Linda, especially if you're a tenant, for your own legal advice. Linda, I can give you 30 seconds if you want to add anything.
Okay. I also have to say, I do represent small landlords, the people who own those 2-family houses or the 6-family houses. They're the little guys, and I do represent tenants also.
And when those little guys are taking in a tenant or want to kick a tenant out, it's not so simple. So you want to consult with Linda or someone else who's knowledgeable about that area of law to work out a lease that's fair to all involved and protect your rights as a small landlord, and to do the litigation properly so there are no adverse consequences. And under no circumstances can you change the locks or throw someone out. That might be a criminal offense.
Oh, absolutely. And that's a criminal offense under New York City law, and now under New York State law as well.
And just serve notices early and often. Again, a lawyer like Linda can help you with all that. And again, it's a complex proceeding, so you just want to protect yourself, especially if you don't have that lease. Linda, do you have more information on your website?
Yeah, www.landlordtenantlaw.net.
So just give it to us one more time.
Landlordtenantlaw.net.
Okay, so I want to thank Linda Rzesniowiecki for being our guest on Law You Should Know. If you missed any part of this program, or you'd like to hear it again, or tell someone else about it, just go to nccradio.org and look for the podcast, and tune in future weeks. Linda will be on to tell us a lot more about the new landlord-tenant law. You've been listening to Law You Should Know, and please join us again next week at this same time on 90.3 WHPC, the voice of Nassau Community College, and also over the internet at nccradio.org.